All right. Good afternoon, everybody. I've started just a minute or two late because I was asked to leave some time for people to join the meeting. I hope everybody who wants to do so has been able to do so by now. My name is Ryszard Piotrowicz. I'm Professor of Law at Aberystwyth University, and I'm very pleased and honoured to be able to chair this session this afternoon. And of course, the session is entitled New Pathways for Implementing the Refugee Convention, the Role of International Institutions. And I'm particularly interested in this subject because until a few months ago, I was the Vice President of GRETA, which is the body responsible for monitoring how European states comply with their anti-trafficking legal obligations. And just about 1 year ago, we published what's called a guidance note on the application of the Refugees Convention to people who have been trafficked. So we have been actively trying to contribute to this, and that's why the subject is of great interest for me. We have 4 speakers this afternoon, and I will be introducing them each in turn, not all at once at the beginning. And each of them is going to be looking at different aspects of the role of international institutions in implementing the Refugees Convention. And I think that the best way to do it will be to obviously invite you also, if you have any questions or comments, please to put them in the chat. Each speaker will have 10 minutes, and I have been told to enforce this strictly. So I have what one might call a virtual taser, which I will deploy if anybody speaks too long. And after everybody has spoken for their 10 minutes or so, we will have hopefully plenty of time for questions and discussion. And I will invite each of the speakers to select questions or comments from the chat and to respond to them. So that's how I hope to run the session. I hope it's going to be of great interest for everybody. Now, I do plan to invite the speakers to speak in the order which is on the programme. And if anybody should have a problem with their camera or anything, we can always change the order. But be that as it may, I would like to now invite the first speaker in the programme, Ms. Janja Simentić Popović from University of Belgrade, to give her presentation, which is entitled Interpretation of the Refugee Convention, Opinions of the Advocate General of the CJEU, as between judicial decision and doctrine. Janja, if you're there, you have the floor.
Thank you very much, Ryszard. Thank you for a kind introduction. I know you probably cannot see me because my camera has let me down, but I hope that you can see my screen. Do you see the presentation?
Yes, we can see it.
Thank you. So I would like to use it and to use it to start speaking, to use my 10 minutes in order to, let's say, give you a sketch on one of my interests, which is the Court of Justice of the European Union as the institution which in a way also participates in the interpretation of the Refugee Convention. Most notably, I would like to speak about the opinions of Advocate General, which is a special feature of the Court of Justice of the EU. And the way I themed it is that I put this opinion between the judicial decision and doctrine. Why I did it? Because the opinion of Advocate General is not obligatory in any legal manner. However, some of the legal reasoning of the Advocate Generals find their way into the Court of Justice of the EU and its judgment. Therefore, some parts could be seen as judicial decisions, while on the other hand, the opinions of Advocate General are are structured in such a manner as they sometimes resemble the doctrine or some sort of doctrinary comments. Therefore, it is interesting to note that they are sometimes very much detailed into their discussion on several topics. And today I would like to share with you my views on the role of the Advocate Generals and their opinions in the interpretation of the Refugee Convention. And hereby I will call it the Geneva Convention because that is usually the way they termed it in the framework of the EU law. Just a short introduction on on the opinion of Advocate General, as you can see, Ryszard explained that the opinion can resemble a mini thesis that exposes the legal and factual aspects of the case at hand. And it is also interesting to know that it uses the relevant comparative law, but also the academic commentaries, and we will see more on that later on. My research is based on the analysis of 29 cases in the preliminary ruling procedure regarding the qualification directive, which is the EU directive, which basically in a way implements the obligations of the refugee or Geneva Conventions, and done in the period from 2009 to 2020. From these 29 cases, in 17 cases, in 17 opinions of Advocate General, I found some considerations regarding the Refugee Convention. And here on the slide, you can see also the names of Advocate Generals which dealt with this issue. As you can see, the Advocate General Sharpston, which is a former Advocate General now from the UK, had in quantitative, but I would also say in qualitative terms, contributed a lot to this discussion. It was also interesting for me to point out that the Advocate Generals themselves saw them as, let's say, a relevant body or to interpret the Geneva Convention. And here you can see the words of Advocate General Watlett, in which he stated that in cases in which there is a need to clarify the requirements of the Geneva Convention, the Court of Justice may, if the need be, interpret that convention for the purposes of providing such clarification. So the Advocate General itself was aware that sometimes himself or herself and the Court of Justice will be in need of interpreting the Geneva Convention. We can also find a similar reasoning in the opinion of in the Shepherd case of Advocate General Sharpston, in which I believe she, in a very let's say succinct manner, explains why it is important to interpret the Geneva Convention. She says that the Geneva Convention is a living instrument, and that should be interpreted in the light of present-day conditions. She also emphasizes the role of the UNHCR. This is important to stress because, as I will explain later on, a lot of the Advocate Generals actually rely on different documents of the UNHCR. She explained that the Geneva Convention is the cornerstone of international regime for the protection of refugees, and that the qualification directive, the EU law, must be constructed in light of the general scheme and purposes of that convention. So in these cases, in these 16 cases in which different Advocate Generals had to deal with the Geneva Convention, these are actually the relevant articles which they had to deal with. These are, as you can see, in quantitative terms, it is mostly Article 1D dealing with the Palestine refugees. These are the cases Bol, Elkot, Alheto, Germany versus XT. Then there is also the case on the exclusion clause in the Article 1F of the Geneva or Refugee Convention in 2 cases, and there was also one case regarding the Article 26 on the freedom of movement in the case Alo and Osso. So in terms of thematic, let's say, response of the Advocate Generals towards the Geneva Convention, these are the articles to which they gave their contribution by way of interpreting them in order to apply it in the ambit of the EU law. What was interesting to me to see also is the instruments of interpretation that they used for that matter. Some of them relied expressly on the Vienna Convention on the law of treaties, in which in Article 31 till 33 there is this rule of interpretation of international treaties, which is not something that is usually mentioned in the ambit of the EU law, but here it happens several times. And these are some of the instruments which I saw from the corpus that I analyzed. This, as you can see, most of the advocate generals rely on travaux préparatoires, and in a very extensive manner, if I may say so. They really turn to the meeting of the plenipotentiaries, to the stances of different states reflected therein, and they pretty much give their thoughts using the travaux préparatoires. They also use the aims and objectives of the Geneva Convention in order to interpret it. Here on the slide, you can see the cases. I will not read them in order not to waste time on that, but it is important to note that both, let's say, historic means of interpretation as well as, let's say, evolutionary means of interpretation, such as aims and objectives, are used in the interpretation of the Geneva Convention. It might be interesting to maybe just pinpoint one case, some of the, let's say, more recent cases, which is the case Home Department versus OA. Advocate General Hogan gave its opinion in this case, and it was interesting to me because one of the question was whether non-state actors can provide protection. We're very well aware that the Geneva Convention does not provide that option, and it is some of the contested, let's say, questions in the literature today. But Advocate General Hogan was of the opinion that even though there is no explicit mentioning of the non-state actors in the Geneva Convention, if they do have certain characteristics, then it isn't per se contrary to the objectives of the Geneva Convention. So it is a very interesting, let's say, interpretation of the Geneva Convention. And finally, there is this systemic interpretation in which the other documents or other instruments are used in order to interpret the Geneva Convention. And this is mostly the case with the UNHCR documents used as soft law, and which was one of the topics of the previous panel I attended on this conference. And I would like to dwell more upon it, because it is interesting to note how the Advocate Generals use the relevant UNHCR documents. Again, I will use the words of the Advocate Generals themselves. Advocate General Wetlet stated that it is not binding, UNHCR documents are not binding on the contracting states, but they have a particular persuasive force. On the other hand, it is interesting to note that Advocate General Mengozzi in the other case explained that it is not easy to develop uniform practice in the interpretation and application of the convention by the contracting states, having in mind the large quantity of the documents which are not necessarily coherent. And therefore, we can see, let's say, from these two positions, we can see also two positions of the Advocate General towards the UNHCR documents. On one hand, in some cases, they are in complete agreement with the UNHCR documents, and they use them in order to explain their legal rationale. And there are several cases, not that much, but they're important, in which Advocate General was to a certain extent in a disagreement with the UNHCR proposed stances. So the cases in which I found the agreement are the cases dealing with the, as you can see on the slide, the cases on the grounds for exclusion, on the principle of family unity, and on the fact that there is a strict interpretation of the secession clause.
I should just say, Janja, you have about 20 seconds left.
Okay, yes, I'm finishing. And as for the disagreement, it is usually in the ambit of the Article 1D, which is definitely very interesting, as we will, I saw that we will have another presentation on another panel about it. And finally, by way of concluding, as I stated, sometimes the Advocate Generals, when you read their opinion, they look and they might resemble something that you read in an article. And it is interesting to note that they use in their opinions academic literature, and these are just some of the sources that they used. I also wanted to emphasize that they mostly rely on them.
I'm going to have to.
Okay, thank you very much. Thank you for your attention. I remain here for your comments and questions.
Thank you very much, Janja, and I hope that we will actually be able to see you in person a little bit later when it comes to the discussion. I would like to move straight to our second speaker now. Now, on the program, the second speaker was to be Simentić Popović from Oxford University, but she is not able to speak this afternoon. However, she is being replaced by Jasmine Simperingham, and Jasmine is going to speak on the same subject. And the title of Jasmine's talk is "The Global Pledge Mobilizing the Legal Community to Address Asylum Seekers' Unmet Legal Needs, Forging New Institutional Collaborations to Ensure the Implementation of the 1951 Refugee Convention." And before I give you the floor, I think I can see you've just won the prize for the longest title of paper in this conference. So Jasmine, you have the floor. Thank you. 10 minutes.
Okay, thank you very much. So I must say, as was said, that I'm not Stacey, I'm Jasmine. So the longest title belongs to Stacey, but as do these slides. But I hope that I can do justice to them today. Can you see them? You can see the slides?
Yes, yes.
Okay, great. Sorry, I just wasn't sure. She's using Keynote as well. I really feel like an imposter here. Anyway, just to say that I work for an organization called PILnet, and we're a public interest law network, and we coordinate the global pledge that was made at the Global Refugee Forum. It's a pledge made by the global legal community, and Stacey has been very involved in the pledge, but we work together, and so hopefully I can address any questions that come up today. So just to say that the pledge is the first initiative of its type, and certainly at its scale, to bring together the global legal community to support efforts to protect and find solutions for asylum seekers, refugees, and others forcibly displaced. And so at the GRF, over 80 legal actors, and that includes a very diverse range of local actors. So we have refugee law clinics, local law firms, global law firms, and legal aid and empowerment organizations as well. And they've joined together to make a commitment to support asylum seekers and refugees, and to do that in a coordinated and collective way. So it's a solidarity pledge. I mean, so I guess in terms of the purpose of the pledge, those of us, many I'm sure, are lawyers, we appreciate the value of the rule of law and the key and fundamental role that access to legal assistance provides to refugee response, and how key it is to the implementation of the 1951 Convention. But this is not always sufficiently recognized by the refugee response sector sort of at large, or perhaps even from within the broader humanitarian sector, or indeed donors. So one of the purposes of this pledge is to really bring the global legal community together to give visibility to the importance of the work that the legal community does, but also to address and to identify the notable gaps, legal gaps in legal aid provision and in legal and protection systems. And so a key goal of the pledge is to increase resources in order to support greater access to legal assistance, and to do that in a coordinated way. As those of you who have worked in refugee status determination will know, for example, that when asylum seekers have access to legal assistance, to high quality legal assistance, they have a far greater chance of being recognized. And so, for example, one of the core NGOs that supported the mobilization of this pledge, Justice Centre in Hong Kong, they have developed a collaborative model that brings together a range of legal actors to address a gap in legal assistance in the Hong Kong framework. So in Hong Kong, those on appeal did not have traditionally have struggled to find access to legal assistance, and the Justice Centre in Hong Kong have developed a model where they are the specialized NGO, and they have specialized lawyers in-house, but they work together with pro bono pro bono legal service providers from often global and sometimes local firms, who actually pay money to Justice Centre in order to be part of this collaborative model. And then they also work with law students from Hong Kong universities. And they have developed this model, and through this model, they are able to increase access to legal assistance for asylum seekers in Hong Kong. Not just access, but also have managed to increase the recognition rates as well. So for those asylum seekers that access this model, they have a recognition rate of, on average, 97%, which is a fairly high recognition rate. But what makes that particularly, makes that even more kind of stark is the fact that the average recognition rate in Hong Kong is 0.08%. So, I mean, this is an example of the kind of collaborative model where bringing together the legal sector and a variety of actors can really add value and really add capacity where it's needed. So that is a key goal of the pledge, is to showcase and highlight and explore and unpack these net models and support others to undertake them as well. So to that end, there were, as I said, a number of private sector actors on the pledge, and those private sector actors committed 127,000 pro bono hours annually each year towards efforts to support protection and solutions for asylum seekers and others forcibly displaced. And last year, we've just issued a report, and I can share a link to it in the chat, but they actually provided over 165,000 pro bono hours. And that's just from the private sector. I mean, that's not even counting the countless hours that the legal aid organizations that joined the pledge and some of the local actors provided as well. So we can see that the legal community has a core role, and this pledge is about uniting and ideally trying to support greater resources for the legal community. So that all sounds really great, but actually operationalizing the pledge, it's an inherently complex task and something that I think about a lot. So while it's a global initiative and it's innovative and linked to the Global Refugee Forum and has at its heart a whole of society approach, because it has such a significant component of it that involves legal service provision, and legal service provision is inherently sort of a localized, it requires localization. It's incredibly important that as we implement this pledge, we do so in a way that acknowledges the fact that legal service provision is localized for the number of reasons that I've put, that Stacey's outlined there, including that, it's inherently, legal service provision is provided within a certain jurisdictional framework and often requires locally qualified legal practitioners. It also needs to respond to the needs on the ground of the communities that are being served and the asylum-seeking population in those communities. And it also often involves connections to other community organizations and other leaders, and it's really something that can't be done at a global scale. It has to be localized. So in terms of this initiative being something that can contribute meaningfully to greater legal assistance and greater access to justice and rights for refugees, the initiative stands in contrast to other initiatives because it's not about norm setting or policies or legislation that the national governments can spearhead. It's or be encouraged to spearhead. I mean, it's really a different kind of beast. And so as we start to think about how we're to operationalize it, we're doing so within broader conversations that are happening in the humanitarian sector about localization, essentially. And so to do this is not something I do alone as the coordinator with PILnet. There's a core group of NGOs, including Justice Centre, including Stacey, and including many other actors that have come together to support the operationalization and the growth and the sustainability of the pledge. And so in the last year, there's a number of activities that we've undertaken, and we've listed a few there, but just to highlight, I mean, something interesting that's coming up on World Refugee Day is that we're going to launch a portal, an online portal that aims to match the legal needs that are identified by NGOs and legal service providers at a local level with the pro bono hours that have been pledged through the pledge. And then, as I said, there's the annual report, which outlines a number of other examples of the kind of work that we've undertaken so far. But I mean, the pledge is in a very nascent stage. We don't see it as being a a pledge that will be implemented tick by the next Global Refugee Forum. I mean, there are some of those that are, but this is actually more of a movement that we see being, an effort that we want to continue to grow around the world. And so I must say the pledge remains open. So if there are any actors that are interested in coming on board or want to learn more about it, of course, I will also include my details and feel free to get in touch. But just to say that as we are looking to operationalize this, we really are, we're concerned about the fact that while we can play a valuable role, PILnet, as a institution that is known for matching, sort of having a pro bono, we call them clearinghouses for those that don't know.
Sorry, Jasmine, you have about 30 seconds left.
Sure, okay, sure. But just to say, while we can play that role in a good way, in a useful way, we are worried that as we look to increase resources for legal assistance, that we don't act as a gatekeeper. So really, there's a lot to unpack and there's a lot to think about, which is something that Stacey and I are doing together, drawing on some of the scholarship around localization, which again, I won't touch on, but just to say we will unpack further in a working paper. And just to say that there is a lot of
I think that
approaches.
Time is up.
Okay. Okay.
Sorry to interrupt you, but I've
no, that's fine.
I've been threatened with severe sanctions if I don't keep people to time. So
no, that's absolutely fine. I'm here for any questions. It's absolutely no problem. I've done that role. It's horrible.
Thank you very much. Thank you very much for that, and I'm sure that we will hear from you later in the discussions. I would like to move straight to our third speaker now, and our third speaker is Dr. Jerome Elie, who is an independent researcher based in Switzerland. And Jerome, I hope that you're there, and I would like to give you the floor now.
Thank you. Sorry, I was trying to put my PowerPoint, which is very handmade, homemade. Hope you see it. Can you see it and hear me? If you could.
Yes, everything is good.
Good. So, well, thank you for coming, all of you, to listen to this panel and to this presentation in particular. So, again, the presentation on the compact and the evolution of what I call the architecture of solutions. At the root of this research was the feeling that we lack specific analysis on the compact through a solutions lens. And this was surprising to me, because the compact's paragraph 85 is clear in indicating that facilitating access to durable solutions is one of its primary objectives. And indeed, I would argue at the start that the four interlinked and interdependent objectives that are listed in paragraph 7 of the compact are all strongly related to the three traditional durable solutions. We recognize easily voluntary repatriation, resettlement, and also, I would think, maybe somewhat in disguise, local integration, and we can discuss that. Such analysis is also important, I think, because the compact goes beyond listing the traditional durable solutions, envisaging a mix of solutions. So really my interest at the start was to understand what this mix might be, and what innovations or evolution this may represent for durable solutions or not, actually. In reflecting on this, I came to wonder whether we can or should build on the notion of interlinked and interdependent objectives, as you see on the screen still, to highlight an architecture of solutions. Some have argued that a compact aims to develop an architecture of burden and responsibility sharing. So can we extrapolate on this and say the same for durable solutions is one of my questions. Given the limited time, my presentation will not dwell too much on details, but also because I have to say this is work in progress. And one of my objectives with this meeting is also that I'm genuinely interested in hearing from the audience whether this is at all useful and makes sense. So just quickly to go to explain how we proceed, I will come back quickly on the notion of the three durable solutions with reference to the 51 Convention. Then I would look quickly as well on the New York Declaration, the CRF, Comprehensive Refugee Response Framework, and the successive drafts of the compact, highlighting, I think, some confusion, but also around solutions, but also a process of crystallization. Finally, I will present my interpretation of the architecture of solutions. And maybe as a teaser, I hope you can see everything despite the videos. Here is basically what I will be talking about. So maybe that will interest you to stay till the end. But for the moment, the three traditional durable solutions. Here, my original question, I'd say an historian's reflex, was where does the tradition come from? Why do we talk about three traditional durable solutions when actually this terminology and the structure does not appear explicitly, at least in the convention, and not even, I would say, in the UNHCR statute, which says more on solutions. Again, sorry, this is not a question that I will answer now, but I'm working on it. For the purpose of today, I would say that this indicates that the notion of the three durable solutions has been subject to evolution, to interpretation, and has a history of its own. What is meant by durable or permanent, the term in the statute, is also important. Basically, I suppose this refers to when international protection is not anymore needed. This indicates for me that before reaching the ultimate stage, there is probably a number of intermediary steps and processes at play, and I'm not necessarily saying anything new here. So I think a discussion on the number of durable solutions, their content, and even labeling is relevant because some have argued that the compact did not speak of three durable solutions anymore, but about 5 sustainable solutions. The New York Declaration, the CRF, and the drafts of the GCR have contributed, I think, to this perception, or at least brought some confusion as to how the compact relates to durable solutions. So first, to look at the New York Declaration and the CRF. The New York Declaration reaffirmed the commitment to actively promote durable solutions and to expand legal pathways. The Annex 1 to the New York Declaration, the CRF, which we need to remember became an integral part of the compact, is also interesting and maybe confusing. Again, I hope you can read because for me it's hidden by the videos. Here you have the paragraph 10 of the CRF, which indicates that basically the section on durable solutions focuses on voluntary repatriation, local solutions, resettlement, and complementary pathways. So obviously there is a glaring omission with local integration, which is a terminology that is nowhere to be found actually in the CRF. And also, I think we can say that many would also question listing local solutions and complementary pathways as part of the group of durable solutions. However, also to recognize that while local integration is not mentioned in the CRF, it does refer to naturalization. So things are not necessarily as simple as it looks. The successive compact drafts, and here to clarify all the drafts and how they went in sequence, I think carried on with this level of approximation, but ended up with a clear position. And here I would flag that first, from the very beginning, the famous zero draft, the text talked about a mix of solutions, as I mentioned. The clarification about what this included and meant came later, quite late, actually, I would argue, with the draft 3. But it is interesting that the idea of a mix was there from the beginning. Second, for a long time, there was an important confusion, or at least lack of clarity around local integration and dynamics with local solutions. And until draft 3 again, there was no specific section on local integration, although the section on local solution was basically about local integration. Third, a clear mention of durable solutions in the opening paragraph of the section on solutions appeared with draft 1, which is the second, 0.1. But it took time to come up with a clear listing of those durable solutions and their relationship with other elements. And again, that came with a draft 3. So the solution, my reading then is that the level of confusion and unclarity that existed in the previous drafts and the CRF was somewhat lifted with draft 3 and 4. The compact in paragraph 5, and you see that on the screen, ends up being extremely clear on the fact that we have 5 elements when it comes to solutions, but with the reaffirmation of the 3 durable solutions. The other 2 elements may provide additional opportunities. So now, what does this all mean, and how can we interpret the dynamics between those elements? Coming back to the architecture. So I have here 2 main positions to make, based on the notion that the compact does present us with 5 separate elements on the solutions, but through a 3+2 structure, or maybe 2+3. First proposition is that we have the 3 durable solutions reaffirmed clearly, and in addition, we have complementary pathways and local solutions, which are not solutions in themselves. I propose that those be interpreted and mobilized as interim stages, intermediary solutions, or simply pathways, avenues to solutions, to durable solutions. To make this first proposition a bit more original, I had a second one, which is to challenge the usual pairing of complementary pathways with resettlement and of local solutions with local integration, and to propose a less siloed approach. Of course, this pairing makes sense in many cases, and we can find rather explicit references to this in the compact itself. One can understand that local solutions may lead to local integration, while complementary pathways are almost always considered jointly with resettlement. But can we say, for example, that complementary pathways always link to or complement resettlement? Or maybe more to my point, could complementary pathways also lead to other durable solutions? Well, I think this was the interpretation of the authors of a document which is the key considerations on complementary pathways.
Sorry to interrupt. You have about 30 seconds.
Okay, I'm actually almost done. So this paper, which was actually developed through a multi-stakeholder effort, and which basically, as you can read here, says that what we read is that the complementary pathways can lead to any of the 3 durable solutions. This is about equipping refugees to attain a durable solution, which is directly linked to the self-reliance agenda, the notion of inclusion, as well as the refugee participation agenda. And I believe this is also true, also applicable to local solutions. So my conclusion, I actually have no time to conclude, and I didn't plan for that. Just to ask you the following. I'd be really interested to hear if you think all this matters in practice, if whether we can make use of this architecture in the programmatic terms, and whether there are risks, and whether the compact offer tools, the right tools for this. Thank you.
All right. Thank you for that, Jerome. And I would just like to finish by offering my sincere condolences for the decisive defeat that Switzerland will suffer against Wales in the European Football Championships at the weekend.
I'm French, so.
Oh, well, that's okay. Okay, thank you very much. Thank you. And I hope people did manage to hear the questions that you put at the end. If there were other questions you wanted to raise but didn't have time, maybe you could put them in the chat, and people will be able to read them then. So thank you very much for that. Our final speaker in this session this afternoon is Sarah Scott-Ford from the University of Copenhagen. And the title of Sarah's talk is Surrogate Judicialization of Refugee Law, the Formation of Pathways between Nordic Asylum Authorities and UN treaty bodies. Sarah, you have the floor. Thank you.
Thank you very much. And I believe that my screen is sharing now.
We can see it, yes, or I can.
Thank you very much, Ryszard, and thank you to all the panelists. That was very interesting to hear about. Now I'm going to jump in and talk about the Nordic migrant cases of the UN treaty bodies. So there is an ongoing scholarly debate about the role of human rights in migration cases and the role of institutions in particular. On the one hand, scholars argue that human rights oversight may ultimately harm realities on the ground as states circumvent their responsibilities, pushing violations further into the margins and perhaps leading to state backlash. On the other hand, some migration scholars, though, remain optimistic about the potential of human rights litigation. I look at cases lodged at the UN treaty body's individual complaints mechanism that primarily deals with immigration. The overwhelming amount of these cases actually deal with the risk of refoulement lodged by rejected asylum seekers against Western democracies. So the big question is, of course, whether this has any effects on the ground. Taking a Nordic regional perspective, I find that although the views or the decisions are limited with a non-binding force, the interpretations have been taken up in courts and quasi-courts across the region. As they do so, these decisions become embedded in specific contexts and national immigration practices. To set the scene, let me show you the total amount of cases lodged, that is immigration related, against the Nordic countries, and the amount of these that result in a violation finding. So Denmark has the highest amount of these cases by any country, and Sweden follows shortly after. This is also in the global stage, so to speak. In comparison, Norway has remained quite low, and it's also mostly scattered across the last few decades. Whereas for Finland, the cases are quite new and pertain to procedural errors, mostly in the aftermath of the 2015 crisis. And the cases appear to continue to be lodged as well. And as a quick side note, the variation that you see here can also partly be explained by routes to national judicial reviews that differ between the Nordic countries. Let me also break this down by the committee. So as you see, the Danish cases are lodged across the treaty bodies. I should be clear, there's a considerable amount of diversity. Although predominantly at the Human Rights Committee, which is the yellow bar, you see conversely that with the Swedish, Norwegian, and Finnish cases that they're primarily tried at the Committee Against Torture, which is coded.
Sarah, can I briefly interrupt you? I'm very sorry, but I think we are only seeing your title screen, Surrogate Judicialization.
Oh, no, okay.
So I at least can only see the other slides in the margin, and they're not big enough.
Okay, thank you. What about now?
I don't know. Thank you.
Okay, let's just do it like that. Thank you very much for jumping in, Richard. Okay, so let me just quickly take a moment to jump back into the total cases, because I think that's really important to just see the amount as well, now coded by committee, where you see this diversity play out. And over time also, it does differ between the countries. So if we look at Denmark, there wasn't much going on with the Danish cases before a spike in cases, which began around 2015 and led to a lot of violation findings around 2015 to 2017. So if you see the number of cases over on the left side. If we look at the Swedish cases, it looks quite different because the cases started much earlier and has been sort of consistent over the years, up and down, with violation findings ranging in an average of 0 to 3 every year. But before I turn to the effects of all this litigation, I want to say a few words about the broader trajectory of this case law. Why do we see this increase at the UN treaty bodies? The involvement by the treaty bodies should be understood as part of larger movements that have taken place within migration and human rights law. And the initial move is characterized by general accountability terms where human rights have begun to have more implications on the ground. In the migration domain, human rights courts began to address the rights of migrants, which had previously not been overseen by an international court. This is what Thomas Gammeltoft Hansen has called surrogate judicialization. So this shift effectively reshapes the international regulatory framework, but it's ultimately a fragile form of accountability. As you can see below on the screen now, these routes change as doors open and close. So here it's well known in the European Court of Human Rights that it became effectively closed off for many migrants' claims after the changes to interim measures following reforms in 2012. And if you see on the red bar, the success rate drastically lower for all Nordic countries by 2013 already, and has remained steadily low ever since. Turning back to the Nordic countries, there are two predominant reasons why migration cases feature significantly. Firstly, there's been a rather dramatic shift in the Nordic region from a more generous or humanitarian refugee policy towards more minimalist interpretations of international law in this domain. And likely related to this, there's been a lot or a significant amount of strategic litigation where cases seek to draw attention to broader issues. And so here the treaty bodies offer more than just a last way to get a residence permit. Taking claims directly to the venue of authoritative human rights interpreters makes sense, given that the treaty bodies also operate a reporting mechanism where systemic critiques can be taken up. And we saw this, for instance, with early decisions against Sweden, which fed into concerns about the lack of appeal rights and the independence of the former asylum system. Decisions might also feed into broader national discussion aided by the media or civil society. Now, returning to what it does, I want to highlight four main dynamics. First is that adjudication does have a national effect, contrary to many other areas where the treaty bodies weigh in on national courts' decisions. This domain has a clear international orientation, and they may already need to take into account international interpretations, which is the case in Swedish and Norwegian law. In all four countries, there is scope to reopen cases after a violation is found, and this is often done at the first instance. But at the same time, oversight on asylum matters is controversial. The central question is, how may treaty bodies meaningfully review non-refoulement claims against their respective treaty while not coming into conflict with the weak form of judicial review required by their supranational role and also commonly practiced at the highest level of national judicial review of asylum cases. So especially interpretations which deal closely with matters of discretion, such as the credibility of the applicant, open a gap for critique on whether they have veered too far off their subsidiary role. This difficult maneuver is clear in the cases themselves. For instance, we see many strongly worded dissenting opinions that accuse the majority of overstepping their role in these cases. Also, in the Danish response to the influx in violation findings, they also argued for a narrower judicial review of asylum claims. The Refugee Appeals Board frequently commented that the committees had become a kind of appellate trial and that the committees had problematically placed themselves in the role of the authorities. Beyond the question of violations, though, there are many cases that go under the radar. Many cases have been dropped at the UN level after it was reviewed again in the national system. So in Sweden, there is a particular rule that statute bars cases if they have been pending after 4 years from the final rejection. And some council deliberately try to draw out the case through an international procedure in order to start afresh in the national system. Also, more cautious treaty bodies like CJEU has also used several of its inadmissibility findings against Denmark to communicate that the convention indeed has extraterritorial scope and how gender-based persecution should be understood in light of the convention in the national arena. In this way, the admissibility decision contributes to the conversation and, in theory, pushes the dialogue about how asylum claims should be understood in light of human rights down to the courts or quasi-courts. At the same time, there has been a sense in the scholarship that the views are sort of in the shadow of a regional court issuing binding decisions. And we do also see this in the Nordic region. There is some evidence that national courts indeed refer to the case law of the European Court to trump broader practice changes that are suggested by a treaty body decision. Also, in the Danish example, authorities have contested the implementation of several repeated violation findings by pointing to other decisions from Strasbourg.
Sarah, you have about 30 seconds left.
Perfect. And in cases where a conflict might exist, they tend to display allegiance to the court. And this is, of course, in light of, significant pushback to the European Court, but we do see that there is sort of day-to-day practice, mostly an adherence to what the views find. Finally, I want to ask whether this is sustainable. It remains a fragile form of accountability. The UN treaty bodies have long been under-resourced, and the waiting times have since increased, putting further strains on these kinds of cases and the amount of times that states may uphold interim measures. Since the treaty bodies have been quite access-friendly, if they become perceived as an immigration appeals tribunal, they could face similar state backlash as the European Court, or states may just fully decide to not give heed to any of the views. Thank you for your time.
Sarah, thank you very much for that. Okay, we have heard from all four of our speakers now in this session. There are a number of comments and questions in the chat, and the way I would propose to do this is to invite each of the speakers in the order that they spoke. So starting with Janja, to go through the chat and to pick any questions or comments to which you would wish to respond. And I think we can allow up to 5 minutes for each of you, and then we'll take it from there if there's still some time left. So Janja, if you are ready, would you like to?
Yes, I am. Can you hear me?
Yes, I can hear you very well. And
I hope that maybe you can also see me now.
Yes, we can see you.
Yeah, okay.
You've brought our afternoon to life. Yeah.
Thank you. So very nice to hear from you, to see you. And I would also like to thank you for the question which was posed in the chat. The question is about the disagreement that I highlighted about the Article 1D, which stands in contrast to the more common attempt to find common interpretative ground. And Ruby asks what explains this divergence and what are its ramifications. And I would like to first, again, thank you for the question and maybe explain a bit. So Article 1D deals with the Palestine refugees, and I might quote the parts of the disagreement in which the Advocate General Sharpston, in the case, first case in which she dealt with, that was the case Bol. And there she's basically the issue was how to interpret it, two parts of the Article 1D, and she says that they should be interpreted consecutively, not disjunctively. She says that, I quote, here I disagree with the line of interpretation proposed by the Office of the UNHCR, in which states in 2002 note, and more clearly in 2009 revision of that note, that all Palestinians who are outside of the UNRWA zone are not at present receiving protection or assistance, and consequently that protection or assistance has ceased. Therefore, this means that assistance could theoretically cease for someone who has never received it, which is simply does not fit in with the natural meaning of the word cease. Therefore, in the disagreeing here with the interpretation put forward, I am guided primarily by the clear text of the provision. And she explains that her intent is to read the two sentences firstly by assessing whether a person was ever receiving the UNRWA protection and whether that protection ceased, and only when that is assessed, then we can make an assessment whether and which protection can that person claim, whether that is the ipso facto protection of the convention, or whether that person needs to go through the refugee status acclamation de novo. So the issue is, as she claims, about the understanding of the two parts of this formulation. And what I believe that explains this divergence is the fact that the UNHCR documents are, let's say, based in abstract. I mean, they are based on the practice and they are updated, but they usually give us some guidance in abstracto. However, when Advocate General deals with a case, she or he has to deal with a case and relevant facts of that case, which are sometimes are particular. Therefore, Advocate General sometimes needs to go into more detail and to maybe tackle some more issues in a different manner than it was done by doctrine or by UNHCR documents. So that might explain that fact. Also, I would like to point out that the same Advocate General Sharpston in some other cases had a slightly different opinion on her own previous interpretation, whereby she explained that she will change her opinion in light of the facts of the new case. So what, if I may just conclude, what can explain is not the very let's say disagreement in abstracto, but the fact that the Advocate Generals deal with the concrete issues and the concrete facts of the cases, while UNHCR documents are more abstract. Therefore, there is the need to precise them and to, let's say, put them in the perspective of a relevant case. I hope that answered your questions, and thank you once again for asking it.
Thank you very much. Yeah, and there might still be some time later if there are other questions or comments that you would like to respond to. I would like to move straight on now to Jasmine and give you the floor and for you to respond to any comments or questions that take your attention.
Yes, absolutely. So there were two questions by the same person, and they're excellent questions because they're the kind of questions that I think about all the time. You've spotted, so there was a question about, is there any risk that pro bono legal activities might, in some contexts or situations, hamper the emergence of a specialized, economically viable class of refugee lawyers? Now that's one question. Same person asks a second question, and I think I'll read it out as well because my answer addresses, I think, both. The other one is that, is there any risk that some categories of asylum seekers might enjoy less opportunities to access pro bono representation for reasons not directly related to the merits of their protection needs? So, I mean, yes, there's a risk of those things, but I would say it's a minimal risk, and that the benefits of involving the private sector and supporting pro bono, greater pro bono participation and pro bono refugee rights around the world are far greater than the risks that you've outlined, because the pledge is not just about pro bono. I mean, the pledge is about collaboration, with pro bono being sometimes a part of the good practice models that we're identifying and we're trying to support and resource and provide visibility for. It's only one small part ever. And the responses to legal aid and the legal assistance programs that, you know, we're seeing, the most impactful ones are always local led by economically viable refugee lawyers, ideally. So our goal would be to support, you know, the development of a viable class by, you know, advocacy. So I haven't touched, obviously I had 10 minutes today, so we haven't touched on some of the other components around sort of advocacy, around government funding of legal aid. That's also a part of this pledge. There's, you know, so say that pro bono, it's not that we're saying that pro bono is the answer. It definitely is not. It is just that pro bono can provide additional capacity, but it will always need to be led by specialized asylum refugee lawyers. So I guess that's sort of an answer to the first one. And just to say as well that pro bono, we're not just talking about pro bono for asylum legal support. So I can share in the chat as well a menu of pro bono services that we put together with UNHCR and the core group members. So in many cases, the legal needs of asylum seekers and refugees are not asylum related. You know, they might be about family reunification, they might be about livelihoods issues and conflict with the law in other ways. And so that is also where pro bono can add value. If you can connect, as we've done on a number of occasions, if you can connect an organization that's working to provide asylum support with lawyers that are providing other kinds of support on a pro bono basis, then that's a fantastic way of supporting and creating an additional resource for asylum seekers. And so I guess that's in response to the first question. And I guess in response to the second question, it's kind of a similar answer, is that we don't promote private sector and nor do, as we understand, any of the private sector signatories on the pledge just support, you know, go and cherry pick people that they, you know, asylum seekers somehow to represent. all of them that we understand, I mean, that they work with local legal aid actors, and it's the local legal aid actors who identify and refer those cases. So it's not done in a vacuum. It's not sort of done, you know, with the private sector just going off. It's very much in collaboration. So, I mean, there's always these risks, but I think that the models that we're proposing is that a specialized legal aid provider, a specialized asylum legal aid provider would be the one that is leading, and that we want to support additional funding, you know, to bolster that. Thank you. Okay, looks like I've answered your question. I'll stop there then. But anyway, I mean, do get in touch, and I will put a link to the pro bono menu of pro bono services, and feel free to contact me if anyone's interested to learn more. I'll stop there.
Jasmine, thank you very much. And we have still about nearly 20 minutes left for the session. So I want to move immediately on to Jerome to respond, and then we'll have time for Sarah, and hopefully still a few minutes for any further comments. So Jerome, please, you have the floor.
Thanks. I've identified 3 questions on the chat, and 2 that maybe be linked together at least. First one from Jeff Crisp, which is about whether there should have been, the compact should have said more. The need to facilitate transnational mobility, which is an outcome, if not a solution, in the classical sense of the word, for many refugees. Should it have, maybe, you know, the question of should it have is has to be related to the whole process, which was you know, the process of taking out text and concepts was complicated in the process itself. It would probably have been useful, and maybe not just in relation to solutions, also to protection aspects. How, you know, transnational mobility, facilitation of transnational mobility can also help in terms of protection. But I don't think it's totally absent. I mean, it is mentioned, at least, you know, labor mobility is mentioned, I think, twice. Once in the multi-stakeholder section, highlighting the potential role of, I think, the private sector. And then, of course, in I think paragraph 95 on complementary pathways. So it is there. It's maybe not developed enough, and the kind of thinking and work that I propose is actually geared towards developing a bit more meaning behind some of the elements that are in the compact, which couldn't be fully developed. I think it's a rule for a lot of elements in the compact. Even some of the main arrangements is that you are not going to have extensive TORs, for example, for any groups that is or arrangement that was developed. That is the work that comes later. So I think it's still something that can be done. Then moving on, there was a question from Dr. Ruvi Ziegler, referring to I think a chapter written with Fatima Khan in the Oxford Handbook. I assume the latest one. I think I see which chapter it is, but I haven't read it yet, and will put that on top of my list. I mean, the question is basically, I think 2. One is whether the compact, whether I agree that the compact prioritizes voluntary repatriation, voluntary in brackets, and de-emphasizes the significance of acquiring state citizenship. Yeah, I think this is relatively clear. Something I didn't, well, the history that I showed, you know, quickly, and there would be more to say, shows that, but also that there's been a corrective at the end that, you know, really section and the word, the terminology local integration has been used, but for a long time it was not really there, at least not in the headings. But still now, if you read the sections outside of the section on solutions, there is very often references only to, in a sentence, to VOLREP and to resettlement, not to the rest. So on that, I think it's clear, and there's a number of ways to explain that, but I think the political context is certainly was certainly one. Whether I agree with calling, so the question then was I think calling other local solutions as non-durable solutions, pragmatic way. My answer to that is, and that's beyond your question, why call solution something that is not durable? And for me, here a solution needs to be durable, or linking to the next question, even permanent. So the pragmatic way is, I think, as I see it, is the way I presented in my presentation. It's more to see them as an avenue, as a tool that will help equip refugees to attain a durable solution, rather than calling it a solution in itself. So I hope that answered the question. And then that leads to a question from Malcolm Elie, and I hope I'm pronouncing that right, the name right, which is basically, I understand, the question around what are the elements that constitute a durable solution and what makes it durable. So bouncing back on what I just mentioned, I think what makes a solution durable is that and what I mentioned during the presentation is that it brings an end to the refugee status. It brings an end then to primarily to the need for international protection. Basically, the person is back under the protection of a national state, and that's what I think is the main element of a durable solution. And so I would agree that permanent is I mean, I think would describe the requirement better. And that's where also in terms of local integration, I still fail to understand why we don't say that the local integration is naturalization. Long-term resident status for me is too broad or vague and does not necessarily mean a permanent or durable solution. But the fact is that's one element. Then, what makes it durable, or what is a durable solution? Here, I would say that I don't have my thoughts yet completely formed, but I tend to come to think that there is actually only one durable solution, which is integration. Integration in a new community, integration in the former community. And here I don't even say reintegration, because I think even with voluntary repatriation, very rarely you would have people reintegrating in the exact similar community, the exact similar context, the exact similar situation. So, so it's maybe we can say it's not that there is only one solution, but that the common and determining element to each durable solution is integration, and how we can make sure that the integration is permanent or durable. And here again, I think the two terminology we need to think a bit more. I will stop here. I see there are other messages, but maybe not for me.
Thank you. Thank you very much, Jerome. And I would like to move immediately to Sarah. We have about 10 minutes left. So Sarah, please, you have the floor.
Thank you. Thank you for many very good questions. Let me start with Catherine's question. Thank you very much. I also love your work on the UN treaty bodies. So the question was about the wider impact. You all have the question there, so I will not repeat it. In the Nordic region, it does differ a bit when you look at what's the broader impact of the views. So for instance, in the Danish system, it's taken up at the second instance at the coordination committee of the Refugee Appeals Board, and they'll consider whether this has to lead to a practice change. And of course, it also comes in light of the significant influx in findings. So there has been a lot of resistance, as is not surprising with the amount of cases that spiked. Also came at a time where there was a lot of international criticism towards Danish practices overall. So there was a little bit of a sort of legitimacy battle that you can see in the Danish example. This differs with the Swedish cases that are sort of different overall. And generally they're taken up, they're reopened, and in all cases that I know of, it results in a residence permit. So either on a humanitarian basis, complementary protection, or some asylum, of course. In Norway, it's quite different. There, we also have a Supreme Court that generally sort of takes on the role of interpreting international law and sees itself as a court that in itself is equipped with doing that. And it's also why I think you don't see the kind of strategic litigation in Norway, among other reasons, of course. Otherwise, like the broader practice, whether it, not just the one case, but beyond it, does require more research. Sort of depends on what exactly you're looking at, and it also depends on, as I was saying, how much it really comes into sort of the credibility territory, and whether they might respond by saying, well, here we take a different approach. The second question about the outsourcing of RSD, I'll just say a quick comment on that. There has been a lot of criticism in the region and from civil society and international organizations like the UNHCR for outsourcing RSD. So it's probably quite unlikely at the moment, although I'm not the best person to ask, frankly. But it's likely that other states will still follow, and we don't know what could happen. But yeah. Just follow that along as you will. There was also a comment by Jillian just now about why there is the kind of strategic litigation in Denmark and Sweden. So that differs. With Sweden, they were quite early in seeing immediately, well, here we have an explicit article in Non-Refoulement. There was an earlier case against Switzerland just a few years earlier, and then they had an early success. So already in 1996, and that sort of, there was an early spike already by 1998. And then it sort of continued a little bit, So there was a pathway to the European Court and also a pathway to the UN treaty bodies around the same time, but actually started kind of earlier in the case of taking cases to commit to the Committee Against Torture. So for Denmark, we really only start to see strategic litigation when the pathway to the European Court really changes with the interim measures. And I think it was also partly inspired by NGOs from Sweden. There have been some workshops. There's some, sharing of good practices and that kind of thing. So in that sense, it gets taken up more and more. And then with Finland, it's still really early days, but it also seems like there is more NGOs getting involved, and it has to do with the influx of many asylum seekers after the 2015 crisis. Then there was a comment from Hugo Story about the Vienna Convention, and thank you for that. That's certainly very relevant also in a broader sense, of course. I think I'll just say to that in the Nordic states, what we do see sometimes with sort of state behavior is that they try to separate out the different obligations of public international law, sort of formally saying, well, we can kind of split different obligations and that way uphold our obligations, and at the same time also take this kind of minimalist approach. But what we see in practice when we look at these types of cases is that it is much more fluid what is going on, and it isn't, you can't really uphold that stance, for instance, in practice. I hope I addressed all of the questions. If not, feel free to flag it. I was reading along. Thank you so much for very good questions.
Thank you very much for that, Sarah. We have about 5 minutes left before I officially have to call an end to this session. So I would like to invite any of the four of you, any of the four panelists who wishes still to respond to something or to say something, maybe to take some of that time to contribute, please. Jerome, please.
Yeah, if I may, just to say that I forgot to add maybe one or two elements to the question from Jeff about transnational mobility. There are a number of hooks that exist in the compact. Famous paragraph 12, which relate to mixed movements, to the cooperation with IOM, but also to sudden onset natural disaster and environmental degradation that leads to displacement. So here again, I think elements linked to transnational mobility appear. And also here and there, you can find allusions or explicit or less to the Global Compact on Migration. And one is particularly hidden in the paragraph 101, where it says that the follow-up to the Refugee Compact will be done in ways that foster coherence with other processes and actions related to people on the move. And in earlier draft, the phrasing here was related to UN processes on migration or something like that. So again, I think there are a number of hooks and ways to try to bring some more clarity about what the text says, and sometimes maybe to propose interpretations that can go further. Thank you. Thank you for a very interesting panel. Over.
Does anyone else of the three of you wish to make any further comments or response to anyone? Okay, well, it looks like we have silence, and I think this might be a good time, since it's almost 4:20, for me to finish off the session. I would like to thank all four of you very, very much for your presentations, for being very tolerant of my rather strict timekeeping, but it was very important. I think it's been very interesting. A lot of questions have been raised, and I'm very pleased also that you've gone to so much trouble to try to respond to them. I would like to, so I thank all of you on behalf of myself, and of course on behalf of the audience and the conference organizers. And as a final point, I would just like to say to the organizers, I don't know if there's any plan to make a list of participants available along with emails of participants for all of us who have been attending this. And I realize some people may not wish to have their contact details in there, but you can have them excluded. But I hope that that might be considered. So I think, unless any of you, a last chance, if any of you wishes to say anything else, any of the four of you? No. Okay, we'll finish there. Once again, many thanks, and I now call this session to an end, and I look forward to listening to speakers in the rest of the conference. Thank you very much.